Okay, welcome everybody. Good morning and welcome to the Shenkman Private Client Group Accountant Attorney Fall Webinar Series. This program is entitled What Your Estate Plan Isn't Doing. For those of you who don't know me, my name is Jonathan Shenkman and I'm a financial advisor, portfolio manager, and an accredited investment fiduciary at Oppenheimer based in New York City. The goal of all my programs is to bring professionals together to better help them serve their clients. This is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between a client's attorney, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not-for-profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. In addition to the 15 to 20 events I run every year, I also do a fair amount of writing on the topics of investing and financial planning. You can read my work in Barron's, Forbes, Kiplinger, the Wall Street Journal, the CPA Journal, Trust and Estates Magazine, and many other periodicals. My most recent piece was published in Forbes entitled 7 Mistakes Affluent Investors Make. After the program, I'll send out a link to this article and a variety of other periodicals where I publish my work. Today, we're privileged to hear from Matthew Rappaport, Vice Managing Partner of Falcon, Rappaport, and Berkman, PLLC, based in Long Island, New York. Matthew concentrates his practice in taxation as it relates to real estate, closely held businesses, private equity funds, and trust and estates. He advises clients regarding tax planning and structuring for commercial real estate projects, all stages of the business life cycle, generational wealth transfer, family business succession, and executive compensation. He also collaborates with other advisors when they encounter matters requiring a threshold level of tax law expertise. Matthew currently serves on the Sales Exchange and Basis Committee of the American Bar Association section of Taxation. He has authored articles for Thomson Reuters Journals of Real Estate Taxation, The Tax Advisor, Bloomberg BNA's Tax Management Real Estate Journal, and the Journal Taxation of Investments. Today, Matt will be speaking on what your estate plan isn't doing. And with that, I'll turn it over to Matt.
Thank you, Jonathan, for having me back. I can confirm at least that the bio still makes me sound a lot cooler than I am, which is always reassuring. Thanks a lot for coming by this morning. A couple heads up. One of them is, if you hear my infant daughter, Naomi, in the background, she can't yet give out legal or tax advice. I think she's about 6 months away from giving legal advice and about a year away from giving tax advice. So if you hear her try to chime in, don't mind her. She's very eager. She hears me giving out legal and tax advice all day, and she really wants to get in on the action. So you may end up hearing that in the background, but pay it no mind. Anyway, for those of you who don't know me, especially after that introduction, you can take a look at the slide for a moment and get a feel for me and what my practice is about, and you can also avert your eyes from my ugly face. And in addition, you can take in this lovely disclaimer in which I basically say, today is not legal or tax advice, and please don't implement anything without retaining me and then come back and sue me. Brief overview, because this is a lightning round, half-an-hour version of this presentation. I will get into each of these different things, but I won't give it a very deep treatment because of time constraints this morning. But I will cover ideas about business planning and dispute resolution, tax and asset protection, and then lack of follow-up and attention to detail on the basics. Seriously, I feel like I think there's like 100 people on this program today, and maybe 98 of them know more about estate planning than me. Hopefully some of this is new information for you, but nevertheless, I think you ought to walk away with at least one new idea from this morning, and that's really what it's all about. At the end of the day, after I hit 10 years in practice, or 10 years after I got out of school or whatever, and at least it gave me enough of a vantage point to see what the industry was doing and what the industry was not doing. And I feel like a lot of these things are techniques and different approaches that the industry is not doing. So of course, always interested to hear your commentary and then hear people correct me. There are luminaries on this program like Bruce Steiner and Mike Rudiger and other people who are really, really good at this, as opposed to me, where I'm just okay at this. So if any of you see me commit an error or something, just feel free to chime in and offer your thoughts, and then maybe within this half-an-hour time slot, we can discuss. So anyhow, jumping right into it. Buy-sell planning, probably the most common place where I see suboptimal planning all over the place. Generally, I think the agreements leave too much to chance. Probably the worst part of all of the standard buy-sell agreements that I see is the method of valuation, especially the three appraiser rule. For those of you who are on the program who are forensic and valuation accountants, how many times have you had the thrill of preparing your own appraisal report with painstaking detail and then going out and seeing the other side prepare their report and then having the two of you try to agree on a third appraiser to break the tie? This is so dumb, especially because it wastes time, it wastes money, and it doesn't really do a lot to avert argument. What I like to do is I like to name the firm in advance on the agreement itself, preferably with at least one backup firm, if not two. You could, of course, name a firm and all of its successors and interests, and as long as the firm is sufficiently large or prominent enough, you ought to have a firm for the succeeding 50 or so years where the buy-sell agreement might kick in and the triggering event might take place. For those of you who are in accounting firms that have valuation departments, regardless of whether you're a part of the valuation department, this is a nice way to get yourself some extra business without a lot of extra effort. So if you are a tax partner at a regional accounting firm that has a robust forensic and valuation wing, and you're doing business with estate planning attorneys and you're sending out business succession work to them, if they're drawing up the buy-sell agreements, it's a nice marketing thing to have them name your firm's valuation department, right? You split the expenses among the buyer and the seller, and then everybody has agreed that the firm is capable, that it'll be neutral, and that if it's being paid by both sides equally, it ought not to be influenced by who's cutting the check. So that's the first thing that we like to do. I like to name the firm in advance. Second thing, in terms of methods, we go ahead and we leave the firm to its own devices in terms of determining the best approach: asset approach, income approach, market approach. One of the things that we do, if you have parties that are friendly business partners, or if you have parties that are family members, is that sometimes we cap the valuation discount at 20%, because we feel that if you were to prepare a valuation report for purposes other than the estate and gift tax, right? And when you have a buyout due to a buy-sell agreement, you're not really doing it for estate and gift tax purposes directly. When the guardrails come off, some of these valuation discounts can get really, really high. And for the selling party, that's not incredibly fair, right? If you have a selling party that's got like 25%, the valuation discount could be really steep. So sometimes we limit the valuation discounts, and that way everybody ought to walk away, at least while they might be gritting their teeth, they understand that the process was fair and that it saved everybody the most amount of time, money, and headache possible. Methods I hate: yearly revaluations. That's on some old stuff. Buy-sell agreements that have yearly revaluation clauses are really, really bad because courts tend to uphold them as binding. So if you haven't done them in 5 years, then the most recent revaluation could end up standing before a court of law, and that would be really, really bad. It's almost always inaccurate. So that one's terrible. Formulas, sometimes we do it, but it's only at the client's insistence. Really, formulas really do not reflect fair market value in the truest sense, and that's why we tend to stay away from them. And then the stated price, man, oh man, we've seen one or two of these where it's stipulated in a buy-sell agreement that the stated price of a business is $1 million. Oh, that's awful, because it's almost always inaccurate, and then one side or the other gets totally screwed, and we hate this stuff. So for buy-sell planning, we like to name the appraiser in advance, and we make sure we specify the terms of the buyout as closely as possible in the agreement. A lot of times agreements are only specifying maybe half the terms. They leave the other half to negotiations. It's not really the way we like to do it. Instead, the way we like to plan out our buy-sell agreements is the agreement stipulates pretty much all the terms: down payment, all the terms of the promissory note, and you actually attach an exhibit promissory note to the agreement so that somebody can just graft it, fill in the names of the parties and all of the relevant financial details, and then just go ahead and complete the transaction nice and smooth. Some of the stuff you're going to specify in there. The interest rate, we like prime as determined by the Wall Street Journal, JP Morgan Chase, whatever, but specify how you're going to determine the interest rate. And it should be pegged to the prevailing interest rate at the time. Amortization schedule, we like 20 years with a balloon payment. So it'll be 20-year amortization, 10-year term. You have a balloon payment at the end. Typically allows you enough time to go look far in the future and determine what type of financing you're going to need, for instance. So that's the way we like to do it, but you can customize that to your heart's content. Frequency of payments, we like payments monthly, but you could do them quarterly, you could do them semi-annually, you could do them annually. We don't like to make them too infrequent because the selling party is not going to get paid fast enough. And typically speaking, when you're dead or disabled, you want that money more frequently. So we like monthly, but you don't have to do it monthly. Ultimately, all this stuff is customizable. Just make sure that you're specifying this stuff, because you don't want lawyers from both sides to start being obstinate and delaying the process and putting unnecessary roadblocks in there. So you want to specify all the terms as closely as possible. In terms of triggering events, we see the following stuff covered most of the time: death, disability, retirement, divorce, bankruptcy, or commission of a felony. The one thing you need to be careful about is, how do you define disability? If you have tied disability to an income or a buyout policy or both, you need to make sure that the disability definition in the agreement is calibrated with the disability definition in the policy, because what you don't want is, you don't want a triggering event in the agreement and then no disability under the definition of the policy, or vice versa. You got a policy that's paying out, but you have no disability under the terms of the agreement. That mismatch could really lead to headaches. So if you're going to do a buy-sell agreement that is tied to disability and you have an insurance advisor working on the disability policies, whether they're income or buyout, you want to make sure that the definitions match. What's typically not covered that we like to put in our agreements, but they're equally important: if you have a buy-sell agreement for a professional entity, you want to make sure that you govern the terms of a loss of professional license, whether it's temporary or it's permanent. For instance, you're doing a buy-sell agreement for a law firm. You want to account for what happens if there is a total loss of license, if there's a suspension for 6 months or something else temporary. If you have sanctions that are not resulting in an inability to practice, but you're still getting censured, or you're somehow getting another form of sanction that comes down from the bar, what do you want to do in that event? That should all be specified in any professional buy-sell agreement, for a professional entity. Commission of a tort, that could be sexual harassment, that could be employment discrimination, that could be causing a physical injury, that could be the commission of professional malpractice. Commission of a tort ought to be in there because it is materially harmful to the business. And if the tortfeasor ends up being obstinate about exiting the business, then there ought to be a mechanism for the remaining partners to buy that person out or expel that person without any payment. So commission of a tort we consider to be important because it's probably got an equal amount of frequency as the other stuff that's commonly covered. And a simple dispute between the partners. The thing is, there are many schools of thought about how to resolve the dispute between the partners. There's, of course, good old-fashioned litigation, and at least you want to specify the forum and the governing law in that event. You could have alternative dispute resolution. You could have binding arbitration. You could have non-binding arbitration. Non-binding ADR is kind of a waste of time because the loser is just going to go back and appeal. So if you put arbitration in there, it should at least be fine with binding. Texas shootouts are nifty. We like Texas shootouts for real estate, for instance, where each party submits an envelope to a neutral arbiter, and then the envelope contains an offer that is both an offer to buy and an offer to sell. Sometimes you have one side submit the offer or the other side submit the offer, but one way or another, Texas shootouts are nifty. They approximate fairness. People sometimes have problems with Texas shootouts, but you should have a mechanism in there that if the partners just happen to have a good faith dispute that they cannot resolve and it turns into an impasse, you want to have a way for the partners to get out of bed with each other if that happens. And then at the bottom, this is pretty intuitive, but the buyout terms tend to differ depending on which type of event has occurred. So if you have done something bad, like committed a felony, committed a tort, or lost your professional license, you probably are getting bought out at par or you're getting expelled for no compensation. But in the event of death, disability, retirement, or divorce, you might just be getting bought out at fair market value. And you have to be intentional about setting forth that the buyout terms are all different depending on the classes of events. And this is the type of detail that we typically don't see when we are reviewing buy-sell planning that has been done by other firms. And that stuff should all be industry standard. In terms of how to structure a buy-sell agreement, there's really two schools of thought, and both of them are equally valid. You'll apply them depending on what the facts are. So you might have a separate buy-sell agreement that is different from the governing agreement of the entity itself, or you might put the buy-sell terms into the governing agreement. And frankly, I think both of them are totally okay. In terms of insurance, you'll see at the bottom, we'd like to establish a separate holding LLC just for the insurance. So you have OpCo, which might be an S Corp, might be an LLC, taxed as a partnership. But in the case of putting the insurance policies together, for both tax and administrative reasons, we actually like to have a separate LLC holdco that's got the life and disability insurance in it. And then it'll eventually pay out to the members, and the members will use it for a cross purchase. That'll get you the best tax results, and it also tends to get you the best administrative results. So that's the way we like to do it. That's the way a lot of insurance companies like to do it nowadays as well. So if you ever talk to attorneys in the home office of an insurance company, that's the way they typically prescribe it. In terms of dispute resolution, right, related to buy-sell, but it's more related to the overall structural planning than the legal drafting. Here's some typical approaches, and these are typically client suggested. These are typically not attorney suggested. Attorneys have seen enough to know better than this. In terms of having multiple children, right, this is your typical dilemma in which you have, let's say, 4 children, 2 of them work in the business and 2 of them don't. One typical approach is, well, give the business to my child who works in a business. That is typically not the best approach, because the children who work in the business end up having to fight off the children who don't work in the business because they're jealous that they didn't get a piece of the family legacy. And given that there's fluctuations in value between the business that a client might have, their real estate holdings, their brokerage accounts, their collectibles, their other valuable assets, the inheritance, by the time that the estate plan goes into motion, the inheritance could be totally out of whack. And even the children who inherit the business can end up feeling bad if the business falls on hard times when the client dies, and then the brokerage accounts and the real estate are worth a lot more money. So you have to be careful with that. Let's say you have a business and it's operating out of business real estate, and the client owns both. Sometimes the client says, I'll give the business to child 1 and the real estate to child 2, right? Well, that's always fun. Child 2 is now child 1's landlord. Typically not the best approach, because that's going to result in fighting basically all the time. And then finally, there's divide everything evenly among my children. Well, now your children are business partners with each other. And if you have certain children who have always worked in a business and other children who haven't, that is going to end up being problematic a majority of the time, because the children who work in the business are not going to want to share power or dividends with the children who did not work in the business prior to the client's death. And in addition to that, you are going to have the children who didn't work in the business, and they might get the idea that now they know how to work in the business. And the children who have always worked in the business are going to be very resentful of that. So all of these approaches don't really work well all of the time. They might work well by chance, but it's not the best approach. So what do? The way we do it is we typically advise clients to divide all their assets evenly, but every asset that could possibly have a put and call option has a put and call option. So in the scenario in which you have 4 children, 2 of them work in the business, 2 of them don't, the way it typically works is the business, along with all the other assets, will be divided up into even slices, 25% across the board. Except the children who have always worked in the business have a call option over the children who didn't. So again, on prearranged terms, just like I talked about 10 minutes ago, the children who work in the business can buy out the children who don't work in the business at their discretion whenever they want. The children who never worked in a business, however, have a put option. So each of them at any time separately could decide that they are going to sell either directly to the children who work in the business, which is our preferred approach, or they could choose to redeem. The put option could be a redemption back to the company, except that typically doesn't get the best tax results a lot of the time. But one way or another, the put and the call options give everybody discretion, and they have built-in dispute resolution mechanisms. So if you have the children working in the business saying, hey, we don't want to have the other children involved in this, they can go ahead, they can exercise the call option, and they can yank the other children out of the business. And the other children don't have to feel so upset because they're going to get a lump sum of money, or they'll get paid out in installments. So either the children who are doing the buyout can go get bank financing, or they can pay out of cash flow from the business in installments, whatever they feel is going to be best for them in the business. On the other hand, the children who own non-controlling business interests, they can go in, use their put option, and they can convert their holdings to liquid cash. But if everybody's going to get along, maybe they can stay in the business and they can own equal shares and it'll be fine. And you could throw in, by the way, recapitalizations in which the children who work in the business have all the voting, the children who don't work in the business have no voting. And there's a lot of ways to put variations into this, but we feel the options are by far the best way to ward off disputes. If you want to have extra liquidity, you could supplement the options with an ILIT. The extra liquidity could hold over the children who are getting interest that never worked in a business before. And if they don't want to sell so quick, if it wouldn't be so good for the business, maybe you could have the put be delayed until 2 months after the triggering event or the transfer of interest. And the ILIT could hold over the children who are holding the put options. And the children who hold the call options can use the money they get from an ILIT for extra liquidity to go ahead and buy out their siblings. So it's all around that it ends up being pretty good. I mean, ILITs are, in my estimation, the magic bullet. And maybe I'll have time in 5 minutes to expand on life insurance. But life insurance, when used the right way, is really fantastic. And I'm a big proponent of it. But it just has to be used the right way. So I hope a lot of that stuff was helpful in terms of buy-sells. Asset protection, very, very quickly. In terms of DAPs, you can't really do a DAP in New York. I'm assuming that given that everybody is friends with Jonathan Shenkman on this broadcast, you're all tuning in from New York or maybe New Jersey. New York very recently adopted its own version of the Uniform Voidable Transactions Act. And if you take a look at the commentary in that legislation, you will see that New York definitively said if you have an out-of-state DAP, it totally doesn't matter. So for anybody who has been either advising their clients or for anybody who knows people who have done like Nevada hybrid DAPs and they live in New York, they're not, I don't think they're really going to be effective. So DAPs in New York, not so great. DAPs in Nevada are great. DAPs in Connecticut just adopted DAPs as of January 1st of this year. Connecticut DAPs, they're fine if you're in Connecticut. So DAPs, you have to be careful. In terms of non-DAP states, I don't know why people don't use lifetime Q-tip trusts more often. But by the way, I don't like going offshore either. I don't know if any of you had that pop into your head, but I don't like offshore DAPs either because I just think that there's literally no way optically to defend offshore DAPs when you get in front of a judge, but whatever, reasonable minds may differ. But in a non-DAP state like New York, lifetime Q-tip trusts are magic. I mean, seriously, as long as you administer them properly, you can customize them to get any tax results you want. You can have huge amounts of flexibility in terms of distribution of assets. And even if you have a Q-tip with a general power of appointment for the recipient spouse, you could even protect against the death of the recipient spouse by having the recipient spouse exercise a testamentary general power of appointment, setting up a trust that goes back to the donor spouse. So you could even do that, and all of that is kosher in terms of asset protection. And you don't have to worry about the exemption because the Q-tip trust is a deductible gift anyway, and the assets are includable in the recipient spouse's estate. So I like that. I mean, I don't know why people don't use that more often. There's a couple drawbacks, right? There's what if they get divorced? If they get divorced, you can have them do a post-nup agreement. But if you're funding the Q-tip trust with marital assets, you're probably going to get judicial reformation or dissolution of the trust anyway when you go before the divorce proceeding in family court. And then in terms of death, again, you could do the general power of appointment in a Q-tip eligible trust. And alternatively, you could set up an ILIT the other way, and you could have life insurance. So really, lifetime Q-tip trusts are magic. I think they're awesome. I implement them for doctors and lawyers and accountants all the time. And I think that they should be used a lot more often than they are. One thing to watch out for, a lot of people like floating spouse provisions if you are doing this in only one direction and you're not really getting the other spouse involved. I get that from time to time. The only problem is that anything with a floating spouse provision is not Q-tip eligible. So you have to be really careful for that. Lifetime asset protection trust. This is for generation 2 and beyond, by the way. So this is like generation 1 is dead. Now you pass everything down to the kids or the grandkids. Seriously, I see 1, 2, 3 trusts way too often, and that is age 1, age 2, age 3. I have mandatory distributions of principal. Why are we doing that? Please don't do that anymore. If you're not doing that, you have to convert to lifetime APTs like now, in which the children may take over the trust as a co-trustee with removal and replacement powers of their other co-trustee at a specified age, call it, I don't know, 35. But 1, 2, 3 trusts, I mean, I still see them used and they're terrible. Springing SNTs, if your standard form does not have a springing SNT in it, what are you doing? Like, put it springing SNT so that somebody else doesn't have to go to court and do all sorts of gymnastics in order to do an SNT. If somebody finds out that a child or grandchild is disabled or has supplemental needs, or if somebody ends up with a life event that has supplemental needs involved. I mean, I was administering a living trust that didn't have a springing SNT in it, and we had to do all sorts of gymnastics because one of the children had major kidney issues and was on Medicaid. And Medicaid was the only way that he could survive. It was a mess, and it was very, very tense seeing whether or not he might lose his benefits. Eventually, thankfully, he didn't. But if you don't have a springing SNT in your forms, you need one. So I hope that this at least wakes you up if you don't have it. IRA trust, after the passage of the Secure Act. By the way, and Bruce Steiner's on here. Bruce is literally the world's foremost authority on all things IRA trusts. So if you ever need to go look him up and get in touch with him, he's at Kleinberg, Kaplan, Wolf & Cohen, and he's smarter than me by a factor of about 9. IRA trust at this point after the Secure Act, I think Bruce was in agreement with me even before the Secure Act that conduit trusts were like not good, or at least they weren't optimal, and why are we using them? Every trust should be an accumulation trust in which the trustee has discretion over which income and principal to distribute, because I guarantee you that taxes will be way less of a concern than asset protection when your child's on heroin, okay? And I've had it happen before. So no, you shouldn't have all distributions be mandatory. You should be able to retain flexibility and whatever. And the main reason why IRA trusts are really important is because Clark versus Remacher said that non-spouse beneficiaries of retirement accounts don't get any asset protection. So you have to make sure that the retirement account is wrapped up in a trust so that you get the asset protection you need. Trust protectors, truly not standard because New York State does not recognize trust protectors by statute, except that I put them in everything. Trust protectors are a new animal. They originally came from offshore trusts, but they got brought onshore about, I don't know, 20-ish years ago. And trust protectors can really be, they can be customized to serve almost any role that they permissibly could serve. We use them in our forms as a luxury for the trustee. We don't use them as a beneficiary protection mechanism. Sometimes trust protectors are used so that the beneficiaries could get some level of fairness or equity in terms of administration of the trust. We don't really do that. We do that so that the trustees can sort of get off the hook. Professional trustees like them, by the way. I should complete that thought. Trustees can get off the hook for things like withholding distributions, for decanting, for other things that might implicate their fiduciary duty. Professional trustees like trust protectors because it lets them decrease their liability without changing their fees. So the professional trustees love them. But this is a legal mechanism that's still in development. Trust protectors are kind of, they're kind of a newfangled thing. But if you don't know about them, you can look up material by a guy named Alexander Bove, B-O-V-E. Bove is the leading authority, I think, in the nation in terms of trust protectors and how they work. And if you don't have them in your documents or you don't really know about them, you should know about them. I'll leave off on advanced directives for the next 2 minutes. In terms of healthcare proxies, I see 8-page healthcare proxies. If you ever talk to an emergency medicine physician, they'll tell you that that is totally stupid. Healthcare proxies should be 1 page. That's it. HIPAA disclosures are actually not necessary because healthcare proxies are allowed HIPAA information by statute. So, like, I don't understand that. Living wills. I don't know if most of you know this, but New York is not a living will state. Living wills are only recognized by judicial precedent, not by statute. So I don't do living wills because healthcare proxies should be sufficient, and you should be advising clients to have conversations with their healthcare agents about end-of-life care. So healthcare proxies, they should be 1 page, and I don't even do living wills. I know that's controversial, but I don't do them. Jonathan, I'm turning this over to you in like 30 seconds. Don't worry about it. Durable powers of attorney. You might want to get a separate one for business matters because I don't know if you'd want a spouse in there doing business functions if you have non-spouse business partners. So think about doing 2 different powers of attorney, a full one for estate planning, separate one that's limited for business only. Disposition of remains, it's just setting forth what people want to do with their remains when they're gone, because it doesn't really belong in a healthcare proxy or a living will. And then standby guardian, what happens after you die, but before the surrogates court names guardians. That's what the standby guardian is all about. If you are advising people with children who are single, you want the children to do to do all their advanced directives because parents lose automatic authority when they turn 18. And for kids who have kids, right? If you have grandkids, okay, you want to get insurance on your children and their spouses if they're not going to do it. Why? Because if they die, then your retirement is the one that's going up in flames. So you should protect yourself, really, or you should advise clients to protect themselves. And then finally, please follow up after you're done with all the signing, because the other advisors are going to make your planning a lot better by collaborating with you. Make sure your beneficiary designations are synced up with all the documents, because you could have a bunch of beautiful documents, and if most of the estate is in retirement accounts, then if you don't change your beneficiary designations, that and life insurance, then all of your beautiful documents are next to useless. So you should be mindful of that. Anyway, Jonathan, you take it away from here. I hope this was useful information, and if you want to reach out to me, go ahead and use all this contact information on your screen. And I can give you the slides too, by the way.
Great. Thank you so much, Matt. It was a great presentation as always. If anyone has any specific questions, new business opportunities, any other issues they'd like to discuss, please feel free to reach out directly to Matt or myself where appropriate. I will include his contact information in the email following this program. As I mentioned at the onset, the goal of these programs is to stay up to date on timely wealth management related topics and to collaborate where appropriate. And I think we can all agree that the clients who are best prepared are the ones who are served by a team of knowledgeable advisors. Just one more item before I let you go. My next program is on October 26th at 8:30 a.m. and is entitled U.S. Citizens Living in Israel, Trust, Real Estate, and Income Tax Considerations for a Dual Tax Person, featuring Boaz Feinberg, who's a partner and head of tax at Tadmor Levy and Company based in Tel Aviv, Israel. You'll be receiving an email tomorrow morning with the details and registration information for this and all of my upcoming programs. I hope you can attend. And with that, this concludes today's session. Please stay safe and healthy. Have a good day, everybody.